5 steps to starting your small claims court lawsuit, coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. So grateful to have you. I'm Jordan Farkas. I'm a retired small claims court attorney. I'm also the author of some books on the small claims court. You can check out the video on my homepage of YouTube if you haven't already seen it. If you've already subscribed, thank you so much for doing that. And that means you know a little bit more about me. And in today's video, I'm going to talk about what are the steps to starting your lawsuit. And I want to remind you, if you're just landing on this video and you haven't seen my previous videos, I want to remind you that before you proceed to a lawsuit, there are various considerations that you should take to determine if indeed it's worth suing, where you should be suing, the jurisdiction, who you should be suing, etc. And that's in my first video, in which I go through all these various considerations you should take into account before you proceed to a lawsuit. And in my second video, I talk about the idea of building your case and knowing that you have good evidence for your case, etc. So this third video in the chronology of videos that I've been recording for this channel is talking about a situation where you've already gone through the considerations that I've talked about in the first two videos, and now you're ready to proceed with the small claims court lawsuit. And the question is, okay, well, what do I do now? Where do I go from here? And that's a very valid question, because it does seem somewhat daunting. There's a lot of people that know that they've been wronged and that they're owed money, but they don't know what to do about it. If you've come to this channel, then most likely you were doing some research about small claims court, or somebody owes you money and you stumbled upon this video and you're looking for some of that information. And it's very often that people take it for granted, like, oh, I've got a small claims court lawsuit. Like, go to small claims court. I've seen that on, Facebook groups, all sorts of different chats and whatnot, where people are saying, yeah, go to small claims court. But what does that mean? What does it mean to go to small claims court? So in this video, I'm going to try and kind of demystify that for you. And as you'll soon see, it's not all that complicated, especially in this day and age where we've got all the relevant information at our fingertips. And that's exactly what I'm going to start with. So I've, like I started doing in the last video, to try and make things a little bit more visual for you. And once again, if you're kind of listening as you work or as you do some sort of, home chore or whatever, that's also cool. But for those that are watching the video, rather than just watching me talk all the time, and because I'm not the greatest videographer, as you can see, that hopefully I'll improve on that with time. But the purpose of these videos on this channel is more to give you substance, okay, to give you that information that you need to help you win in small claims court. That's my goal. It's to help you win in small claims court. So without further ado, as I was saying, part of this intention of this video is to help you demystify what it means to go to small claims court. And I mentioned having all sorts of information at your fingertips. And indeed, that's my first step for you, which is visit website. Okay, and I'm referring to the website of the local small claims court where you're in. So for example, if you're watching this from New York, then you're going to simply put in a Google search for New York Small Claims Court. In fact, I did that before this video just to test that out, because once again, to remind you, my home territory, so to speak, before I retired was Ontario, okay, Ontario, Canada. But you can be watching this video from anywhere in the world, obviously. So you should go to the local small claims court website in your jurisdiction, because as far as I'm aware, every single state or city or jurisdiction or town, or wherever the case may be, has a website dedicated to giving you information on how to proceed with the small claims court. And the reason for that is that the small claims court is meant to be a people's court, right? Like the famous television show, The People's Court, and you have all sorts of court TV afterwards, not court TV, but you have court programs, Judge Judy and Judge Joe Brown, all those types of different court shows that are based on being a people's court for the people. And if something's going to be for the people, then there better be information given by the government or the municipality, or whoever's putting out, or the county clerk, whoever's putting up the small claims court information in your jurisdiction, that's meant to be there for you. So as far as I know, every jurisdiction will have a website dedicated to small claims court. If yours doesn't, I'd be curious to know about that and leave that in the feedback. That would help me update my viewers. But let's go with the assumption that you're in a place where there's a website dedicated to small claims court. And that's what you should do, because there, for example, as I mentioned, I went to the New York Small Claims Court. They've got all sorts of information about the procedure for filing a small claims court lawsuit, what's expected of you, how to show up for trial, how to prepare for trial, what you have to do in terms of finding the right jurisdiction. And I talked about that in my first video. So all sorts of information that's going to help you start the process. It's right there at your fingertips. Okay, so you've gone to the website, you've gotten some information, and then the next step is to actually go and proceed with preparing your claim. Now, this is very much going to vary based on what jurisdiction you're at. So, for example, I mentioned Ontario, Canada, where I'm from. The claim that sets out how much money you're owed and who wronged you, etc., is called the plaintiff's claim, at least as of the date of this recording. And in Ontario, you can actually lay out a very thoroughly worded descriptive claim that sets out why you're owed the money, who owes you the money, etc. Okay, versus New York, for example, where you're filling out the claim, it's pretty much a standard form, and you just fill out your information, the defendant's information, and there's kind of these like check boxes where you can check off what happened, and they give you all sorts of options, and you have to try and fit yourself into that header. Now, again, not being from New York, it's possible maybe you can attach a document that sets out your claim in more detail. So I'm not saying you're necessarily bound to use the format that the court's given you. That's something you would have to check out in your local jurisdiction. But the point is that the claim form will be found in almost all jurisdictions that I'm familiar with on the website of the small claims court. And that's where you set out why you're owed the money, who owes you the money, etc. Now, it's important to note that if you are in a jurisdiction where, like in Ontario, you can describe what happened in more detailed format than just kind of a standard form, checking off the box, so to speak, then bear in mind, as I noted down over here, that the claim is really important, because that is what forms the judge's first impression of your case. So when the judge goes to your claim, he or she wants to know exactly what transpired, how, who, what, where, etc. So you want to really take the time to describe things in chronological order, but you also want to leave out any information that's not necessary for your case that can maybe distract the judge from your case. Now, obviously, this is an art form. Being an attorney, I was trained in this, and I have a lot of experience because I was managing the small claims court for the firm I was at, and then I went out on my own and had my own firm, and I did this a lot. So nobody expects you to be perfect, but obviously do the best you can to be mindful of when you set out what you're owed. You do it in a chronological format, starting with dates. On such and such date, I had a contract with this person. On such and such date, this person was supposed to pay me X amount for the following services. I performed the services on such and such date for payment passed, and the person didn't pay me. Therefore, I'm suing this person for this amount. Okay, so you kind of just want to summarize what transpired in as concise a fashion as possible, trying to leave in only relevant information and leaving out extraneous information. Maybe in a future video, I'll talk more about that. But again, not every jurisdiction allows you to have a very detailed claim apart from the format that they give you. So I don't want to do that in this video, but just be mindful, if you are in that type of jurisdiction, you want to prepare a solid, concise statement that really sets out why and how you're owed the money. Okay. Now, the other thing I mentioned here is that, again, in Ontario, and depending on the jurisdiction where you're at, you can actually attach relevant information. So, for example, let's say you have an email where the guy admits that he didn't pay you. He's like, "Oh, I'm sorry, I know I was supposed to pay you," and he doesn't. So you may want to attach that email to your claim. In other courts, for example, what I saw from New York, you only present your evidence once you get to the actual, what they call the hearing or the trial, depending on your jurisdiction. So, whether or not you can attach the evidence will depend on where you are. If you can, just bear in mind that you should obviously put your best foot forward and attach your strongest evidence. Now, there are circumstances where you want to be careful, not only what evidence you attach, also before, as I was saying, when you're describing your claim, you may not always want to show your entire hand, depending on the nature of your case. And again, it's kind of an art form, and it's a bit too detailed to get into in this video, but that is something that I would plan on covering in a future video to give you an idea of how you may strategically word your claim and strategically present your evidence. And when I say that, I'm not saying to be dishonest in any way or to conceal anything, but strategically means kind of like a game of poker. You can have a good hand, and maybe you set up your cards in a certain way because you only reveal parts of your hand with each round of betting. So you want to set up your hand in a certain way as to maximize your chances of success. And there's nothing dishonest about that, although poker is a game of bluffing, I guess. But in this case, I'm not talking about being dishonest. I'm talking about just putting your best foot forward and using the best, most effective strategy. And that's the name of the game here, which is winning in small claims court. So that will be the topic of a future video. But for the meantime, just bear in mind that if you have an opportunity to attach your evidence, you can do that in many jurisdictions along with your claim. And that could help you in forming a very good impression of the judge, because one of the benefits of being the plaintiff, the one suing, is that the judge reads, or is supposed to anyways, read your claim first. In fact, in New York, it's not even clear to me, based on my limited browsing that I did right before starting this video. Again, I just wanted to go to New York as an example jurisdiction. The defendant doesn't even file any sort of defense in response. You kind of just show up to the hearing, and I guess the defendant tells his story and the plaintiff tells his story. But in other jurisdictions like Ontario, you're going to have a chance as a defendant to file a defense in response. And that defense document can actually set out your side of the story, which to me makes more sense, frankly. But every court and every jurisdiction is different. In any event, so that's what we have. We have step one is to visit the website of the small claims court to familiarize yourself. Step two is to start describing your claim by filling out the form. And then step three is to actually obviously go and file your claim. I shouldn't say obvious. Again, what may be obvious to me may not be obvious to you, and that's totally legitimate. I've been doing this for a long time, so I shouldn't take that for granted. But that is the next step. You go ahead and file your claim. Now, in many jurisdictions, you can actually file your claim electronically, and that's a great way of saving time and cost and whatnot. But in other jurisdictions, I believe I saw in New York, as of the date of this recording, which is in October 2024, they're not allowing electronic filing, which was somewhat surprising to me. I think in the future, all jurisdictions are going to be done via electronic filing. But for the time being, if you're in a jurisdiction that doesn't allow for it, then you'll have to go over to the relevant court in your jurisdiction and file your claim. And as far as I know, every single court charges a processing fee with that filing. So when you go to court or to wherever the small claims courts are administered and processed, make sure to bring means of payment. I don't know anybody nowadays who doesn't walk around with a credit card. And in fact, cash is getting phased out more and more as we speak, depending on what country you're in. But obviously, make sure to bring a means of payment. You should always bring identification with you in case that's required as well when you're filing your claim. And then you go and you file your claim with the small claims court, and that gets things kicked off. Step four that I wrote here is to then serve the defendant. What do I mean by serve? Serve doesn't mean serve like a servant. Serve means to provide a copy of the claim to the defendant being the one you're suing, because how else does the defendant become aware of your claim? Now, once again, in New York, I noticed that the court will actually send a claim on your behalf to the defendant at the address that you provided, which is amazing. But in other courts, such as Ontario, you are responsible for serving the defendant with a copy of your claim. And there's all sorts of ways of doing that. You can hand deliver it to the plaintiff yourself. You can get what's known as a process server. You can get somebody to go and serve it on the defendant. You have it right. It's like in the movies, you've been served. So you can have a professional go and do that for you if you don't feel like confronting or approaching the defendant yourself. In some jurisdictions, you can also do it by registered mail, or maybe even email in some places. It really depends on the jurisdiction. So again, that's why it's important to go to the small claims court website of your jurisdiction and find out what the rules of the small claims court determine for you. But just bear in mind that it's not necessarily true that the court will take care of it for you like they do in New York. You may be in a jurisdiction where you have to provide a copy of the claim to the defendant. And that's also why I talked about in my first video, it's very important to get the defendant's name right and make sure you know the right jurisdiction and their address and have all that information with you. Okay. Now, again, I did talk about in my first video, what if you don't know where the defendant currently is or resides? So there's all sorts of different mechanisms for doing that. In New York, I saw that there may be records with the county clerk. In Ontario, there can be things called skip tracing, where you can hire somebody to go and look after where the defendant is. There's private investigation, again, depending on that cost and how much money is owing. In New York, I believe the jurisdictional amount of how much you can sue for is up to $10,000. So if a private investigator costs you $500, it may or may not be worth it to you to spend that in order to locate the defendants that you can sue for $10,000. But if your whole lawsuit is $500, then you have to really consider whether or not it's worth it, which is not to say that you should let the defendant get away with owing you money. Some people like to sue over principle, although as I'll talk about in a future video, it's not always the best idea to sue on principle, because courts can be the Wild West, and you shouldn't go in there expecting things to go always as you plan. Anything can happen in court, which is another reason why you should try and resolve things before court. Again, my intention here with this channel is to help you win, and that's the focus. And the focus is to win always. But you should bear in mind that there are never guarantees in court. Okay, so again, that's kind of a sidetrack, but that is an idea to consider when you're trying to locate the defendant. How much money should you spend on that, depending on how much money is owing? Once again, subject of a future video, but the point being that you may not be in a court jurisdiction where the court provides notice to the plaintiff, to the defendant rather, so you should look into whether or not you're expected to provide that with provide a copy to the defendant, and also how to provide it to the defendant, how to serve the defendant, because different courts have different rules of procedure onto how that's done. Also, in some courts, in order to keep the procedure going, you have to then file proof that you serve the defendant with a copy of your claim. So in Ontario, for example, there's something called an affidavit of service, where you're swearing to the fact that you provided the defendant with a copy. And without that, you cannot proceed to the next step of court. Okay, it seems like New York is different in every jurisdiction. I'm going to say this a lot, and forgive me, but I have to keep reminding you of that, because if I just state things as fact, and you're in a jurisdiction where what I'm saying is completely not applicable, then it doesn't help you at all. So in these types of procedural videos, I have to say that a lot. Future videos, I'll get into ideas of evidence and how to present your evidence and things of that nature that really generally apply across the board, how to speak to the judge. But even then, because the audience of YouTube is so worldwide, I have to keep repeating that to make sure that if you come in at a certain point in my video, you realize that I'm telling you again and again to make sure to check with the local rules of your jurisdiction, which is another reason why it's so important to go to the Small Claims Court website where you're located. In any event, so you've served the defendant with a copy of the claim. If you have to file proof of that service on the defendant, you take care of that. Again, in Ontario, it's called an affidavit of service. So check if you have to prove serving the defendant. And then finally, diarize the next steps. That's step 5. So diarize, meaning put in your calendar, assuming you have one, what the next steps are. So it may be that right after you file the claim, the court serves the defendant with a copy of it, and then they're going to schedule a hearing and send you notice of that to the address that you provided. Some courts may be utilizing email already. So it really depends on depends on the court jurisdiction, but just be mindful of that. And if you see, I would suggest checking with the court as to what the reasonable time periods are. Like, when do they generally schedule the next step from when you've filed your claim? Okay, so in Ontario, there'll be what's known as a settlement conference that follows the filing of your claim. And if it's 6 months have passed, if the clerk, when you're filing the claim, if the clerk tells you, again, you may have filed electronically, but most courts will have a phone number where you can call and get information. So let's say you call, or you go to the court or the jurisdiction where whoever deals with administration of small claims court, and they tell you, yeah, you can expect a court hearing within a month. And already it's been a month that's passed, then I would suggest following up, obviously, with the court to make sure that you haven't missed a very important date, because it's possible something got lost in the mail, or if they sent by email, maybe you didn't get the email, it went into your spam folder. So it's very important to mark your calendar for what the next steps are and what the time period is, so that you could continue to follow up to make sure that you don't miss an important next step in your small claims court proceeding. Okay, so just to summarize once again, we got the 5 steps for starting your small claims lawsuit are: number 1, visit the website in your jurisdiction. Number 2 is to describe your claim. And if you're in a jurisdiction that allows you to do that more in detail, make sure to keep to the facts in a concise but clear, coherent way, as well as to attach relevant evidence depending on your jurisdiction. Step 3 is to go ahead and file your claim. In some jurisdictions that could be electronically, and others you have to physically do it. Pay the court fee that accompanies the filing of your claim, and ensure to bring means of payment when you go to file your claim. And step 4 is to serve the defendant. If that's something that's required in your jurisdiction, provide the defendant with a copy of your claim. And if the court requires it, file proof that you provided the defendant with a copy of the claim in the way that you have to under the rules of your local small claims court. And then step 5 is, and also I should throw in, along with step 5, to diarize the next steps, is to ensure to ask the clerk or call the court, follow up with the court to determine what the next steps are and the time frame, so that if you see that a certain amount of time has passed and you haven't gotten notice of the next step, you can follow up with the court to see if maybe something got lost through the cracks, so to speak. So I hope you found that video helpful. To some, this may be quote unquote obvious, but to others, it may be something that they didn't consider because they don't know anything about small claims court. So if you fall into that category, I totally understand that. And that's why I did this video. And if you feel that I left something out based on your experience and based on what you've learned, I'm always happy to receive your comments and feedback in that regard. Once again, if you've already subscribed to this channel, I appreciate that. And hopefully you'll appreciate being a subscriber as you continue to get more videos and content from me as to how to win in small claims court. And I'm very grateful if you can share this with anybody who you think can benefit from this channel. And until next time, I'm looking forward to seeing you at the next video. Hey, if you like that video and you feel it's going to help you win in small claims court, check out the next video I've got queued up for you. If you haven't already done so, I'd be very appreciative if you hit that subscribe button and the notifications. Definitely helps me, but it will help you not miss a future video to help you win in small claims court. Don't forget to hit that like button and also feel free to leave a comment, and I'll see you at the next one.